A three-judge panel of the Ninth Circuit Court of Appeals ruled last year against the San Diego Sheriff's Department's requirement that a permit applicant show a specific need beyond self-defense to carry a concealed gun in public, calling the policy too restrictive. Now the case is back before the full panel of judges. Joining me with what's at stake are my guests, legal counsel Robert Fagan with the County Sheriff's Department and attorney Paul Newharth, who brought the lawsuit forward. And Robert, remind us of what the county's concealed weapons permitting standards are that led to this lawsuit.
Well, the Sheriff's Department follows state law, and the state law requires that the applicant be of good moral character, that there's good cause for the issuance of the license, and that they're a resident of the county, and that they have a certain course of training in order to safely operate firearms.
What's some of the reasonings behind the rules of who gets issued a permit and who it doesn't?
Well, in terms of the Sheriff's Department, as it stands prior to the lawsuit and as we're waiting for the decision from the Ninth Circuit, something more than just simply writing self-defense on your application is required. And that comes from the Department of Justice, who administers and sets forth the license application. And really what they require and what they say is that in order for an applicant who wants something for self-protection, they've got to provide examples and good cause and explain why they need it for self-protection.
And how do our rules here, the sheriff's rules here, compare to other counties?
Well, there are 58 sheriffs and 58 different ways of doing it. So this sheriff and this sheriff's department believe that we follow what the Department of Justice for the state requires and what good cause is under California law.
Now, Paul, your client, Edward Peruta from San Diego, he sued the sheriff's department after being denied a permit to carry a gun. How come?
Well, he wanted to carry a firearm because he has a concealed weapons permit that, in other states that allow him to travel between his state where he lives in the summer in Connecticut to San Diego where he spends his winters. He's also has an independent journalism online company where he submits and goes into crime scenes and is an initial responder at different times.
But why did he think that the self-defense, particularly that you had to going beyond the self-defense, that's all he had to say, and he didn't think that was right?
Well, his initial application actually was for the fact that he was a journalist and that he did live here and that he had a number of other permits from other states and should be allowed to carry a firearm here. And he was turned down. He thought that should not have been a proper denial of his application. So since he spends so much time here, why wouldn't he be able to have a concealed weapons permit here? Why does he have to show that he's the victim of a crime, wait to have that happen before then being allowed to have a permit in San Diego?
So that's his argument. The state attorney general, though, says that loosening concealed weapons permitting standards would allow more people to carry guns and could threaten law enforcement officials and endanger the public. So I'll start with you. What is your response to that?
That's somewhat of a specious argument because, in fact, they're not trying to legislate or show uniformity within the state of California. They don't like the way the outcome is of the three-judge panel. They were asked by the Sheriff's Department to join at the outset of this lawsuit. The state of California and the Attorney General's office said no, they would not. It's only after the adverse ruling from the three-judge panel came down that they actually became concerned.
Well, let me ask Robert to respond to that as well. Did the sheriffs, are they involved in this case as far as litigation? And do you get a sense that sheriffs really would like people not as many people to carry the guns?
Well, again, the number of sheriffs across the state, they all have different views on that. Fortunately, our sheriff takes a very civic-minded approach to CCWs, and that is basically he understands that it's the legislature's job to pass the laws, and it's the judiciary's job to define them, and it's his job to enforce them. So he doesn't really have a dog in the fight. He's just looking for direction from the courts as to what good cause is.
Since that original ruling to loosen the permit rules back in 2014, has the sheriff's office here seen a spike in applications?
We have. We've seen, I think we have, since February of 2014, we've seen a little over 2,100 applications.
And are you handing out permits?
Well, we continually review them. Right now we're reviewing them for good cause as the statute is written, and those 2,100 are held in abeyance waiting the outcome.
And Paul, do you think this case will end up in the U.S. Supreme Court, as many have suggested, and if so, why?
There's a strong likelihood that it will, just because it's a question that has been posed, it's a question that's being answered in a number of other circuits. It's not going to go away. We're going to need some sort of finality as to this, and the U.S. Supreme Court is really going to be the only body that can provide that to us.
I see. So Paul Newhart and Robert Fagan, thank you so much.
Thank you.